Hello and welcome to the Minimum Competence episode for Wednesday, June 11th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, Trump's tariffs survive appeal, DOJ firings tied to Trump probes, and French Tesla owners suing over Elon Musk political behavior. Let's remember, when people say, I agree with the message but not the method, they often mean they don't really agree at all. And read today's legal news. On this day in legal history, June 11th, 1811, the New York Supreme Court of Judicature decided People v. Ruggles, a seminal case in early American constitutional law and one of the rare recorded convictions for blasphemy in U.S. history. John Ruggles was convicted for publicly declaring in a tavern that, well, I probably won't say it here. If you're interested, just check the transcript, and was sentenced to 3 months in jail and fined $500. What made the decision historically significant was Chancellor James Kent's justification. He upheld the conviction by transposing the English common law crime of blasphemy into American jurisprudence, despite the existence of a state constitutional provision protecting religious freedom. Kent argued that the Free Exercise Clause of the New York Constitution, similar to the First Amendment, guaranteed religious tolerance but did not protect speech deemed immoral or dangerous to public order. He defined blasphemy as, quote, maliciously reviling God or religion, and asserted that Americans, like the English, required religion-based moral discipline to maintain social cohesion. Crucially, Kent held that blasphemy applied only to Christianity, stating that, quote, we are a Christian people, and that moral and legal norms in the U.S. were, quote, ingrafted upon Christianity. This decision represented a foundational moment in American law by carrying forward a religiously grounded common law principle into a supposedly secular constitutional framework. Kent cited Sunday observance laws and other religious references in law as evidence that Christianity remained embedded in the legal culture. He acknowledged tolerance for other religions, but did not extend legal protection to speech critical of Christianity. The decision aligned with Justice Joseph Story's later view that Christianity underpinned American common law, but stood in stark contrast to the secularist interpretation advanced by figures like Thomas Jefferson. Though Kent's reasoning carried weight in his era, it would eventually lose ground. In Burston v. Wilson in 1952, the U.S. Supreme Court effectively invalidated blasphemy laws, ruling that speech critical of religion was protected under the First Amendment. A federal appeals court has ruled that President Donald Trump's sweeping tariffs may remain in effect while legal challenges to their legality proceed. The U.S. Court of Appeals for the Federal Circuit in Washington, D.C. paused a lower court decision that found Trump exceeded his authority by invoking the International Emergency Economic Powers Act, or IEEPA, to impose tariffs. The court called the matter one of exceptional importance and took the rare step of assigning it to the full 11-judge panel with oral arguments scheduled for July 31st. The tariffs in question include broad duties on imports from most U.S. trading partners, nicknamed Liberation Day tariffs, as well as separate levies targeting Canada, China, and Mexico. Trump has claimed that the tariffs are justified under the IEEPA due to threats like fentanyl trafficking and the ongoing trade deficit. Critics argue these are not legitimate emergencies under the law, and that only Congress has the constitutional power to impose tariffs otherwise. The original ruling striking down the tariffs came from the U.S. Court of International Trade on May 28th in lawsuits brought by 5 small businesses in 12 states led by Oregon. That court found Trump's use of IEEPA overreached presidential authority and misapplied a law designed for national emergencies. While disappointed by the stay, the plaintiffs emphasized that no court has yet upheld Trump's broad claims under IEEPA. The U.S. Department of Justice, or DOJ for those in the know, recently dismissed 2 more employees who were involved in investigations concerning President Trump, bringing the total number of terminations related to those probes to 17 since Trump's return to power in January. One of the fired individuals had served as a lawyer on special counsel Jack Smith's team and previously prosecuted defendants involved in the January 6th Capitol attack. The other was a support staff member also tied to Smith's team. Attorney General Pam Bondi reportedly ordered the dismissals. Although both had been reassigned to other DOJ divisions prior to their termination, their past involvement with the Trump investigations was cited as the likely reason for their firing. Earlier, on January 27th, 14 attorneys were dismissed at once due to their work on Trump-related cases. In April, a longtime public affairs official who had represented Smith's team was also let go. The DOJ has not officially commented on the recent terminations. Trump has persistently claimed that the Justice Department unfairly targeted him for political reasons, though Smith's team consistently rejected that narrative in court. These firings raise new concerns about political influence over the DOJ's personnel decisions. A group of Tesla owners in France has filed a lawsuit against the automaker, claiming that CEO Elon Musk's public behavior and political alignments have caused them reputational harm. Represented by law firm GKA, about 10 leaseholders are asking the Paris Commercial Court to cancel their vehicle contracts and recover legal costs. They argue that Tesla cars, once seen as an eco-friendly innovation, are now perceived as far-right symbols of hate due to Musk's vocal support for Donald Trump and Germany's far-right AfD party. The plaintiffs allege that Musk's political affiliations and controversial gestures, such as one during Trump's inauguration that was likened online to a Nazi salute because it was a Nazi salute, have made Tesla ownership socially and professionally damaging. The group also cites Musk's involvement in the Department of Government Efficiency, a Trump-backed initiative to reduce public spending, as further evidence of his deep political entanglements. Public backlash against Musk has included protests and vandalism at Tesla showrooms across Europe and the US. This lawsuit comes amid declining Tesla sales in Europe, where customers are increasingly turning to competitively priced Chinese EVs. GKA emphasized that its clients purchased Tesla vehicles for their environmental and technological appeal, not as political statements. Tesla has not yet responded to the lawsuit. Musk recently acknowledged regretting some of his remarks on X, the platform he owns, after a public dispute with Trump. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, click a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and minimumcompetence.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. Until then, we'll see you back here tomorrow. And remember, I have almost reached the regrettable conclusion that the great stumbling block is the white moderate who constantly says, I agree with you in the goal you seek, but I cannot agree with your methods of direct action.